I may have some very good news about the SCOTUS injunction decision. They may have left in a pretty big carve-out, and I'm not talking about the class action thing, but bear with me, okay? This is gonna get a little bit in the weeds. I have a couple videos up explaining the decision. The Supreme Court just ruled that a district court judge cannot impose a universal or nationwide injunction on one of the other branches of the government. It has to limit said injunction basically to the plaintiffs of the case. However, in a footnote on page 11 of the court's opinion that was written by Amy Coney Barrett, she says this: "Nothing we say today resolves the distinct question whether the Administrative Procedure Act, or APA, authorizes federal courts to vacate federal agency actions." And this isn't the only time the APA is mentioned in this document, but we'll come back to that. APA is an act that grants federal courts certain powers over federal agencies. So an agency is a specific part of the government that has been created to specifically manage or carry out certain functions. It can be created by Congress or a presidential act. For example, DHS, that is an agency. EPA, agency. NASA, agency. Now, despite the fact that agencies are usually part of the executive branch, they each operate somewhat individually, right? They have vastly different functions, so they all kind of have to operate like their own organization. Quick refresher, the executive branch is tasked with executing or enforcing the law. So when it issues executive orders or executive actions, in theory, they are supposed to be guidance or direction with regards to enforcing or carrying out existing laws, which are, of course, written by Congress. Agencies, while they are part of the executive branch, are not going to be run solely on executive orders. They're going to have their own policies and guidelines that can often be determined based on guidance issued in an executive order. So basically, if Congress wrote a law saying like the sky is purple, the executive branch could issue an executive order saying we're going to enforce this by making sure that any mention of the sky being blue is removed from any government texts. And then federal agencies might develop policies or internal guidelines that basically inform its employees like, this is how we're going to try to carry out that order. But the APA basically says that even lower courts can determine whether certain agency actions or policies are in fact legal or constitutional. In other words, according to the Supreme Court, they recognize a strong presumption that Congress intends judicial review of agency action. And the APA defines the scope of review, like how the courts can review the agency actions and the standards they can use to review those actions. Review under the APA follows the same structure as any other case against the government. Someone has to file suit based on a perceived harm caused by an agency action. It can't be used against Congress, federal civilian and military courts, DC and territorial governments, as well as the president. So basically, APA review cannot be used to determine whether or not a law itself is in fact constitutional. APA does, however, allow the courts to either force an agency to do something or prevent an agency from doing something based on certain criteria, like they found that it's illegal or that they're using it arbitrarily to discriminate, etc. This sort of thing kind of came up recently during the Chevron SCOTUS case last year, which you may remember, which basically says that like the law itself sits above all else and all other potential interpretations or expertise of an agency. So essentially, Amy Coney Barrett's footnote says, none of this decision or opinion today says that you can't do what the APA explicitly allows you to do. The APA doesn't explicitly mention injunctions against federal agencies, and Barrett doesn't suggest or explicitly say, at least, that that is still preserved. But Kavanaugh, in his concurring opinion, also mentions the APA a couple of times. And he says, a judge may be asked to issue a class-wide injunction in a class action suit. And in cases under the APA, plaintiffs may ask a court to preliminarily set aside a new agency rule. Preliminarily suggests to me injunction rather than final ruling. But importantly, today's decision will require district courts to follow proper legal procedures when awarding such relief. And most significantly, district courts can no longer award preliminary nationwide or class-wide relief except when such relief is legally authorized. So he's explicitly putting preliminary nationwide relief on the same level as class-wide relief, which, as we know, this opinion permits. He's quite explicitly saying that preliminary nationwide relief can still be legally authorized. Again, the APA doesn't specifically talk about injunctions, but it does grant these courts certain powers over the agencies. And without the explicit prohibition of preliminary relief being able to be granted, it sounds like they're able to exercise all their usual judicial powers in these situations. And to kind of bolster this idea, even more interestingly, Kavanaugh, throughout his entire concurring opinion, very explicitly on multiple occasions repeatedly describes these potential scenarios, preliminary setting aside, which is very specific language and essentially describes the injunction equivalent under the APA. It's explicitly saying that following this decision, the courts will still be able to grant or deny the functional equivalent of a universal injunction to a putative nationwide class, so that's the class action thing, or by preliminarily setting aside or declining to set aside an agency rule under the APA. Interestingly, it does kind of feel like both of them tried to just drop this little tidbit in there to see if anyone would notice or pick it up. But maybe I'm just imagining things. But anyway, what would this mean in practice if I'm not wrong about this? Number one, it would have to be put to the test, essentially. Like someone would have to request an APA review and a judge would essentially have to issue a test injunction equivalent. But if this were to be the case, I imagine what it would essentially mean is that while a district court could not issue a universal injunction against the entirety of the executive branch, for example, if an executive order was issued, like this birthright one, and then an agency like the DHS sought to enforce or enact this executive order, someone could bring suit for APA review over the DHS's policy or actions, and then the judge in that case could in fact issue a preliminary setting aside of that agency action, which again would be the functional equivalent under the APA of a nationwide injunction. So we just need to try it. By the way, I'm not the only one who's thinking that this might be the case. While I was researching this, I stumbled across some lawyers online discussing the footnote. I am not a lawyer, but I am neurodivergent as hell. Last year's Chevron decision seemed devastating at the time, but it may actually be a decision that is strengthening all of this.